Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. And on behalf of Judges Bennett and Golden, I'm pleased to welcome Ms. Lee and Ms. McDonald for this oral argument. Each of you will have 15 minutes to present your argument, and Ms. Lee, you have the privilege to reserve some of your time for rebuttal, and I'm advised that you would like to use 10 minutes for your opening statement and 5 minutes for your rebuttal. So Mr. Hibner will program the clock to start counting down from 10 minutes for your benefit. Unless there's something else to be announced, Mr. Hibner, please call the case and we'll go from there.
Cumberland Advisory Group, LLC versus Martha Arnita Lee et al.
Thank you, Mr. Hibner. Ms. Lee, you have the floor and the clock is set at 10 minutes.
Okay. Well, may it please the court, my name is Martha Arnita Lee. I am representing myself and my husband, Benny Lee. We, CAG, the lot size correction, I want the lot size correction done because our deed, when we bought the property in 2000, the lot size was 45 by 135. Okay, our deed lot 21, not part, I want the record be known that the deed lot 21 was not part of lot 22. And CAG not use lot 21 for loans and stuff because he removed our fence over 2 feet by the survey. We had no trespassing signs out, no trespassing. And our fence was moved over 2 feet toward our property that we already own. Okay, and the plat was moved by the survey. We had this lot ever since I got this lot from the estate of Deandra Bell and from Marion Bowman, which Deandra Bell was her mother, and she was the executive of the lot since her mother and father bought the property in 1956. Okay, then I bought the property from Marion Bowman in 2000, November 22, 2000. And my lot size that she sold me was 45 by 135. Okay, we know that it was encroached. My husband tried to put up a fence. A wrought iron fence with the 45 feet by 135. We knew then that CAG was encroaching on our lot. That's how we discovered that CAG was encroaching on our lot size.
Ms. Lee, as I understand it, there was a fence there and then CAG removed it, and then you and your husband attempted to put the fence back up.
No, we didn't. It was when we bought the property. Okay. Our resident appraiser said no encroachment, and the fence was already here when we bought the property. Around the fence when we bought it. CAG said we was encroaching because the survey that he had came over on our lot size 2 feet, which was already our lot that we own. We have not put up a fence. Now that the fence is on our lot, it's over about 4 or 5 feet. Okay, and I say they are encroaching on our lot. And the plat was changed. The plat was changed from 45 to 43, the plat size by the surveyors. And
now I understand that CAG had a second survey done. Is that correct?
I don't even remember him having the first survey done.
Okay. Did you and your husband have a survey done?
We did when we bought the property. It was by the Edge Group. Yes, we had a survey done in 2000 when we bought the property.
All right, but since this lawsuit came up, have you obtained a new survey?
We hired Perkins, but he went by the deed that was down in Chancery Court. He said he got the measurement from the Chancery Court. But when somebody took our property to the Chancery Court without our knowing, and they changed our lot size from 45 to 43 during that time. We had no knowledge of any of that. They had changed this lot size without us knowing.
Who changed it?
We think the survey did that, sir, without our knowledge.
Ms. Lee, according to what we have, you quitclaimed the property to Mr. Lee and yourself in 2014?
No, I think it was in 16 or 17. That wasn't a quitclaim then, no.
Well, you
No.
purchased it. Was it purchased in your name in 2000?
It was.
And then you quitclaimed it to yourself and Mr. Lee. Is that right?
And I think it was in 217.
Okay, I'm showing 214, but my question is,
14.
there's a legal description in that deed that says that it's 43 feet.
I know, but when I first purchased the property, I had a warranty deed, and on my universal appraisal, it said 45 by 135.
Okay, is this a deed though that you signed, this quitclaim deed?
I did sign it, but I signed it back to myself. Benny Lee, my husband, signed it back to me, and we got the warranty deed back.
Where did that legal description come from? Was that a surveyor that you hired that put down that legal description, or?
What legal? I'm not understanding your question, sir.
The legal description in the quitclaim deed that you signed.
That was what they had up in the Chancery Court records. That was 43 by 145.
Okay.
But that wasn't the original. That wasn't the original measurement and dimension that when we bought the property. It was 45 by 135.
Okay. Thank you.
And so we saying we are not trespassing. The property belonged to us. They call it a disputed area, but those 2 feet, sir, belong to us because it was 45 by 135 when we bought the property. So we want a correction made that the property belonged to us. The 2 feet belong to us.
All right. Anything else at this time? You'll have 5 minutes later. I don't want to cut you off, though.
He put a fence on our property in the back, and we asked in the court to please have him to remove his fence off our property.
Okay.
There was a flaw in his deed also, that he said lot 21 was a part of 22. But it's a flaw in his deed because it was talking about 14 feet of the boundary of 22, not lot 21 being a part of lot 22. There was a flaw in his deed because we have no connection with lot 22. We are a private owned, as we got it from an estate of Marion Bowman. So we wasn't trespassing, encroaching or nothing on nobody's property. There's a flaw in his deed because it said 21 belonged to, it's a part of 22. We're not part of nobody. So we want that to be, have his deed corrected, sir. It's saying 14 feet of the boundary of lot 22. Not a part of, it's the boundary of lot 22.
Very good.
Mm-hmm.
All right. Anything else at this time? Or
I think that's, well,
you'll have 5 minutes, 5 additional minutes after we hear from Ms. McDonald. Thank you, Ms. Lee. Ms.
okay.
McDonald.
Good morning, Your Honors. My name is Kimberly MacDonald, and I, along with Donald Caparella, represent Cumberland Advisory Group on appeal. Your Honors, this case is a boundary dispute regarding an approximately 2-foot wide strip of land between 2 neighboring properties on 2nd Avenue. Before I get into the merits of the argument, though, I would like to briefly address waiver. As we cited in our brief, the Hesmer case explains that pro se appellants must still comply with the rules of appellate procedure. And we submit that they have waived their arguments because they did not substantially comply. Additionally, they have cited documents outside of the record. And as this court knows, Rule 13 limits your review to the facts contained in the record. However, in the event that this court does not find waiver, we submit that the court should affirm the lower court on the merits in all regard. The standard of review for finding a boundary line is a de novo standard of review, but with a presumption of correctness. And not only does the record preponderate in favor of the boundary line being where the trial court found it to be, it overwhelmingly does so. And there's multiple categories of facts in the record that support this. There are deeds dating back to 1977, testimony of the prior owner and resident of the Cumberland property, multiple independent surveys, and Mr. Lee's testimony in court. First, there are multiple deeds supporting that the boundary line was found correctly in this case. When Cumberland Advisory Group purchased 1061 2nd Avenue South in 2014, the deed described the frontage as having 30 feet. Language in these deeds, as shown in the record, were consistent since at least 1977, with having 30 feet of property for the Cumberland property. There was also a house that was built on the Cumberland property that had been there since at least the late 1800s, as Mr. Lee testified in court. When Mrs. Lee purchased the property in 2000, as she mentioned previously, the deeds that she had only ever stated a maximum of 43 feet of frontage. Cumberland presented evidence in trial showing that way back to 1977, the Cumberland property had 30 feet of frontage. And accordingly, the trial court properly found the boundary line based on these deeds. Second, the testimony of the prior owner of the Cumberland property and the prior resident of this property support this finding. Jackie Cox was the previous owner of the Cumberland property and sold the property to Cumberland in 2014. She inherited the property from her father in 2003, Richard Chrisman, who purchased the property originally in 1987. And during that entire time, there was a tenant on the property named John Stallworth, who lived on and maintained the property. In the trial in this case, both Ms. Cox and Mr. Stallworth testified that the chain link fence separating the property represented the boundary line, which had been there since approximately 1987. Mr. Lee also testified in court that it was there in 2000 when he purchased the property, or when Mrs. Lee purchased the property, excuse me. Further, there are multiple photos in evidence prior and after Cumberland Advisory Group's purchase of this property. For example, Trial Exhibit 2 and 5, that show that this chain link fence remained in the same place throughout this entire time. It's shown by proximity to other structures like a nearby concrete column, and it did not move. We believe that there may have been some confusion when there was the demolition of the house on the Cumberland property and damaged a portion of the chain link fence, requiring Cumberland Advisory Group to repair the fence. However, photos showed that it was simply connecting, the repaired portions were simply connecting portions of the chain link fence that had previously existed, and it did not move further onto the property.
Ms. McDonald, is it your contention that the chain link fence correctly marked the boundary line?
Yes, Your Honor, it is. The chain link fence had been in the same place as shown by photos and as supported by testimony, and it had not moved. That was also the contention of Mr. Stallworth, the prior tenant who maintained the property up till that line his entire time he lived on the property. Additionally, in support of this, there were multiple independent surveys that Cumberland Advisory Group had. First, the Cumberland Advisory Group based its knowledge off of a survey that they had done before they even contemplated purchasing this property. They had purchased a property down the road from this property, and Steve Matthews surveyed the entire block, and that includes measuring markers, different landmarks, different measurements of properties, like the properties in this case. And so when Cumberland Advisory Group purchased this property, they asked the same surveyor to verify his work. And it still showed that the Cumberland property had 30 feet of frontage and the Lee property having 43 feet. The moment that Mr. Lee disputed the boundary, which was in 2015, it's undisputed in the record that that was the first time that occurred. Cumberland spent a lot of time and money trying to verify this. They asked their prior surveyor to verify it. They asked another surveyor at his firm to check his work. And then they even approached an independent separate surveyor to perform an independent survey. And all of these surveyors agreed that the boundary line was proper. Importantly, these surveys also showed that where Mr. Lee had placed the wrought iron fence, unfortunately, would have run through the prior existing structure on the Cumberland home or on the Cumberland property. Before its demolition, there was testimony showing that it was placed right up onto the boundary line. And after its demolition, Cumberland sought to move its structure to have a larger setback. And so it might be that the perception of the structure on that property is further from where the fence is, but that's because of that setback. The actual structure, though, the actual fence never moved. Beginning in 2015, Mr. Lee disputed that there was the property line issue, and he claimed that his property should have had 45 feet of frontage. But as shown, that would have subtracted the Cumberland property to only having 28 feet. There's no documentation showing this going back to 1977.
Where are they getting the 45 feet from?
Your Honor, I believe there was an old microfiche that mentioned the dimensions of that property from way back in 1956 that explains that it says 45 feet is a measurement. However, there's no explanation about what happened. First of all, there was nobody to testify to that document. But ever since 1956 to 1977, there's nothing in the record showing what happened. It could have been that somebody deeded a portion of that strip of the property. It could have been that that was a clerical error. Everything shows that consistently since 1977, that was the boundary marker, and those were the measurements of the properties. But you bring up an important point, Your Honor, because even if the boundary line were incorrect, as we argued in our brief, the Cumberland Advisory Group and its prior owners had actually adversely possessed that strip of property. And according to the Supreme Court in the Cumulus Broad case, there are multiple elements to an adverse possession case, and that's exclusive, actual, adverse, continuous, open, notorious, and for the requisite period of time. We have this fence that was there in the same place and had remained so since at least 1987, as supported by testimony in the record. Mr. Stallworth, who was the tenant of the property, testified that he cared for the land, he maintained the land, and that the prior owners, Ms. Cox and her father, Mr. Krisman, had paid property taxes and maintained the property as well.
So property taxes were paid on a 30-foot wide piece of land, not a 28-foot wide.
That's correct, Your Honor. Yes. And additionally, by applying the doctrine of tacking, the prior owners all can combine their successive ownership to meet the requisite period of time here. And so that either way, if it's 7 years with color of title or 20 years without color of title, all elements are satisfied for an adverse possession as well.
Got a point, come in. How to get back on screen?
I'm sorry, Miss Lee.
I'm trying to get back on screen. Hold on just a minute.
Oh, well, that's quite all right. The good news is you've been connected. There you go.
Okay, yeah. My grandson know how to do it.
Well, I use young people to help me as well. So you're a smart person. All right. Thank you, Ms. McDonald. You may continue.
In conclusion, Your Honors, we believe that the trial court properly found the boundary line in this case as supported by the overwhelming support in the record. In the event that the boundary line was not initially correct, Cumberland Advisory Group has adversely possessed the strip of land that's bordering the two properties. And for these reasons, we ask that this court affirm the lower court in all respects.
All right. Thank you, Ms. McDonald. Ms. Lee, you now have 5 minutes to present your closing argument.
Okay, where the 45 feet came from was my universal appraisal. When we bought the property, it was 45 by 135. Plus, when we paid taxes for the first years and the years after until 2016, our tax records show we've been paying 45 and the lot size 0.15. So we've been paying taxes on the 45 feet. That's where we got 45 by 135 at the survey. And she was saying that when I got this property from Marion Bowman, she was the executive. Her family, mother and father, had the property since 1956. And that was 64 years. And they owned the property, and they property records said 45 or 135. And CAG still have they 30 feet. It was 14 by 16. They still have their 30 feet. When he bought the property, he didn't have approval to build because the lot size was too small to build on. John Stallworth and Jackie Cox, they didn't live on the property. So we have invested rights because we've been on the property for about 20 years now. Up until this, it was 16 years when CAG brought the encroachment charges against us. It was a fence when we bought the property. It was a fence there, enclosed fence with the property description that we had. And it said no encroachment. Okay, Marion Bowman, when CAG bought the property, they included us in a re-subdivision that we knew nothing about. Since he said that lot 21 was part of 22, he made us a part of the subdivision that he went with his surveyor. They made us a part of the subdivision that they got included. How can we encroach when we are part of? They changed our record, the plat, from 45 to 43. Okay, he still have 30 feet, and we wanted to say that Marion Bowman lived at 1059 for 64 years, and she for the first few years, she in 2000 before we bought the problem, she was paying 45 by 135. That's what she paid on her tax records, and we got that on our tax record too. That they've been charging us 45 by 135. Okay, and they saying it was no fence. It was always a fence there. When we bought the property, it was always a fence. And we have a universal appraisal. When we bought the property, the Edge group, they surveyed it, and they got maybe a typo error with Wise and Wilson. So they recorded the deed wrong, but it's 45 because that's what we've been paying on our taxes all these years up until CAG went and said it was 43. They changed all that without our knowledge. Mapping changed our lot size from 45 to 43 without our knowledge. So, and Marion Bowman, they've been had the place for at least 64 years. And we want to resume where we misrepresent. Okay. She said we didn't waive our rights. We had lawyers that didn't represent us. We gave them legal documents, but they didn't put anything in the court records on behalf of me and my husband. They kept records, they kept all that hidden, and they didn't tell us that they kept telling us they had filed it, but we found out they hadn't filed anything. Because we went to Chancery Court, asked had anything been filed in our behavior. They said no, nothing had been filed in our favor. So they misrepresented us, colluded with the other side, and never put anything in our defense that we had the legal document to prove we were not encroaching in no time at all.
All right, Ms. Lee, your time is about up. Any last words?
Just hope the court have understanding and give us a fair hearing on this.
All right. Thank you, Ms. Lee and Ms.
Thank you.
McDonald. And we will take this matter under advisement, and a written opinion should be delivered to each of you within the next 2 months or less.